Ratan sir, hello. Yeah. Yeah, you are visible. Sir, can we start? Hello, sir.
Yeah.
Yeah, so I'll start admitting people here as well. Then we can take 1 or 2 minutes to let everyone join. So yes. Before we start a session, to please mute your audios and switch off your videos. Soon we'll be starting with the session. Ratan sir is with us, and we'll just wait for 1 or 2 minutes. So let's everyone join us. We are live on Facebook. So anyone who wish to attend the session on Facebook Live can go there and attend the session. Before starting the session, there is an
Yes, Rahul.
You start the session, sir.
Okay. Good evening, everybody. I have been given go ahead by the organizers. So first of all, I must once again thank you, all of you, for being part of this program. Now, yesterday we talked about some of the basic issues relating to arbitration, introductory issues. And today we are going to go into some nuances. We'll dive a bit deeper into the whole process of arbitration and concept of arbitration. So today, as I mentioned yesterday, that today I'm going to talk about a very important aspect of arbitration, that is arbitration agreement. Because arbitration agreement is the foundation of any arbitration process. You cannot think of arbitration unless you have a properly drawn arbitration agreement. And a lot of thoughts goes into whole drafting of arbitration agreement. A lot of thoughts should go into this process of drafting of arbitration agreement. Otherwise, people are left with complaints against the whole process of arbitration. So one has to take this topic with all seriousness, and I expect everybody to be cautious about what all we are going to discuss today. So first important aspect is, what is the purpose of arbitration agreement? Purpose of arbitration agreement is to relinquish the right to have one's dispute resolved through the court system. Second purpose is to give power to the arbitrator to decide the disputes. Third is, arbitration agreement also defines the scope of the power of the arbitrator. In fact, by virtue of an arbitration agreement, parties create their own system of justice. A private dispute resolution mechanism is brought into place. One very important aspect about arbitration agreement is that it is irrevocable. You cannot revoke your arbitration agreement once you have I think it is being said that there is no voice. I hope everybody is listening.
Yes, sir, you are audible.
Okay, great. So what I was saying is, arbitration agreement cannot be revoked once you have executed an arbitration agreement. Then you have irrevocably agreed to go for arbitration. You cannot at later stage revoke this arbitration agreement. You cannot withdraw yourself from this process of arbitration. So that is very important aspect. Now, arbitration agreement are executed in two situations. One is when parties are not in dispute, parties are writing and executing their main contract in which they are incorporating their arbitration agreement, or they are writing this arbitration agreement separately. In other words, arbitration agreement can be part of your main contract, underlying contract, or it can be written separately at the time of entering into agreement, that as and when dispute will arise, parties will go for arbitration. So this is pre-dispute arbitration agreement. And we have another category of arbitration agreement, that is post-dispute arbitration agreement. So such an agreement would be an agreement where parties will go for, will execute an arbitration agreement when they are already in dispute. So this type of arbitration agreement is called submission agreement. So submission agreement is an agreement whereby parties agree to go for arbitration after disputes have already arisen. It is not necessary that in every dispute, whenever parties will be in dispute, parties will agree to have submission agreement, but it does happen. So that is third aspect. Second aspect. Third aspect I must talk about is separability, nature of the arbitration agreement. It is separate from the underlying contract. So it is called separability. So even if the main contract, underlying contract is held to be void or held to be not valid, it does not per se means, it does not automatically renders the arbitration agreement also void or non-enforceable. So therefore it is separate from the main contract, and that is what is written in your section 16 as well, section 16 of Arbitration and Conciliation Act. Therefore, so far as arbitration agreement is concerned, it should be a valid and enforceable arbitration agreement. What happens is that sometimes people write arbitration agreement in such a manner that it is not held to be valid. Suppose you write an arbitration agreement to say that parties may go to arbitration or to the court. What does it mean? Essentially, it is a pathological arbitration clause. That means that parties may either opt for arbitration or may opt for litigation. So it amounts to uncertainty in the arbitration agreement. Arbitration agreement is a contract in itself, complete contract in itself. So it should be enforceable. Now, if somebody has entered into an arbitration agreement without any authority, or somebody who has executed this arbitration agreement who is not a major, he's a minor. So in all these situations, arbitration agreement will itself be invalid, will not be enforceable. So like provisions under section 29, Section 29 of Arbitration and Conciliation Act, sorry, Section 29 of Contract Act says if a contract is uncertain, it is void. So that applies. So similar provisions will apply to arbitration agreement as well. Now, therefore, arbitration agreement in itself should be valid and enforceable. Another important aspect is that your arbitration agreement should be in writing. This is the mandatory requirement for any arbitration agreement to be enforceable in law. This is the requirement under model law. This is the requirement under our Arbitration and Conciliation Act. It says our arbitration agreement should be in writing. And for this, if you see the definition of arbitration under section 2, it says arbitration agreement will be as per section 7 of the Act. And section 7 defines arbitration agreement to mean that it should be in writing. It can be, writing can be through electronic means, through emails, but it should be in writing. Or arbitration agreement can also be incorporated by reference in one contract. Let us look at a situation where you are writing a contract and you say that agreement, arbitration agreement of another agreement will apply to this contract. Then such a situation is referred to as arbitration agreement by incorporation. So that is another situation. Therefore, in order to have an enforceable arbitration agreement, agreement should be in writing. Now, another important aspect is that arbitration agreement should be for only those disputes which are arbitrable. There are many disputes which are not arbitrable, like offenses as defined under IPC are not arbitrable. There are many disputes. There are many disputes for which you have a special tribunal, or there are many disputes which are determined and decided under a particular special statute, and which, if those statute says notwithstanding anything contained in any act, all disputes will be decided by only this particular tribunal. In that event, you have to assume that arbitration will not be valid with respect to those disputes for which you have special legislations or special tribunals. So that is another aspect on arbitrability. Like in some of the states like Chhattisgarh, Madhya Pradesh, Gujarat, there are provisions for statutory arbitrations. So you have state legislations with regard to work contracts which are arbitrated under a particular act, and for all those disputes you have permanent tribunals which are set up in those states. So even Supreme Court in Lal Babu Singh's case last year only categorically held that if you have a special legislation, in that case it is not arbitrable, and reference was made to section 2 subsection 3 of Arbitration and Conciliation Act, which says that this act, Arbitration Conciliation Act, is not in derogation of any other legislation. So therefore you cannot go to arbitrate a particular dispute for which you have a statutory tribunal or a special legislation. Arbitration has to happen, an agreement has to be, arbitration has to happen with regard to defined legal relationship. So let us assume that you have a contract and disputes have arisen. Now, obviously, with regard to the rights and obligations arising of the contract, parties can go for arbitration, it will be arbitrated. Now, what about tortious liabilities? This is one area you should give a proper consideration. That what happens if there are some tortious liabilities? Some civil wrong has been committed by one of the parties to that particular contract. Now, for that, you should be careful. If your arbitration agreement is properly drafted and it says that any dispute arising out of the agreement will be arbitrated, in that sense, it means that even tortious liabilities of the parties, apart from the contractual liabilities, such tortious liabilities are also arbitrable. So that is one thing we should keep in mind. So it takes care of that phrase, that defined legal relationship. Yesterday we talked about some, in certain situations, parties who are not signatory to the arbitration agreement can also be made a party to the arbitration, and for which we had said that companies or corporations which are part of a particular group can be made party. Assignees, if you have a contract which has been assigned to somebody else, then assignee can also become a party. Subrogee, parent company, alter ego, agency, equitable estoppel we talked about yesterday, that if a particular party has taken benefit of the contract and the arbitration agreement, but when arbitration is being commenced against him and he is refusing to do that, refusing to agree to be party to this arbitration agreement, then tribunal will obviously bind him to this arbitration process. In fact, in my one ongoing arbitration in Japan, I have included a party, impleaded a party who was not a signatory to arbitration agreement, but he was taking advantage of our agreement main contract. So we have said that he cannot take a plea that I am not a party, and his plea is barred by the principles of equitable estoppel. Now we come to the next aspect, some of which we dealt earlier, is about how to write the contract, how to write the arbitration agreement. Arbitration agreement has to be written with all seriousness, because whole edifice of arbitration and its process depends on proper drafting of arbitration agreement. Therefore, you should not write arbitration agreement which are not enforceable, and we call it pathological arbitration clauses. Arbitration clauses which are not enforceable, which are not written properly, are called pathological arbitration clauses. So what should you do? You should create a mental picture of entire proceeding from beginning to end at the time of executing the arbitration agreement. So you have to create a mental picture in your mind that, and you have to close your eyes and think, what if dispute will arise? How everything is going to happen? If dispute will arise, we will have to go to arbitration. If we have to go to arbitration, we will have to appoint arbitrator. Should we appoint one arbitrator or should we appoint three arbitrators? Should we have ad hoc arbitration or should we have institutional arbitration? If it is going to be suppose, then you have to think, where should we have seat of arbitration? Then if you think that if it is an international contract, then you have to think, what should be the seat of arbitration, which neutral country, whether other side would be agreeable to have arbitration in your country, whether you are ready to have arbitration in other side country, if not, which country. Now, even if you agree for a third country, whether you will like to have institutional arbitration. Yes, if you want to have institutional arbitration, which institution you are going to prefer? Now, when you are going to that particular seat, whether that seat is an ideal seat for arbitration, how do you understand that? Whether the court of that particular seat is arbitration friendly or not? How many tiers of challenges are permissible under that particular in that particular jurisdiction and seat of the seat? Suppose you are entering into a contract, arbitration agreement, and wanting to have a seat in a particular jurisdiction, and if in that particular jurisdiction there are various grounds of challenges available to arbitration award, then obviously you will say that that is not a friendly arbitration friendly jurisdiction. If that particular jurisdiction has 3 tiers or 4 tiers of challenges to the arbitral award, then you will think that am I ready to go for so many challenges? Will not entail huge cost? Will that not entail huge time? It will not be cost effective, time effective. There are jurisdictions where court fees for challenge is huge, like in the case of Austria. In Austria, 5% is the 5% of the award value you have to pay if you want to challenge the award. So you will have to look at this. Now you want to also find out whether in that particular jurisdiction I'll get good lawyer. If I want to hire some local law firm, what is the quality of lawyers there? If you say that I want to have a arbitration institution of a particular arbitration institution, whether that particular arbitration institution is agreeable to the other side, whether that particular arbitration institution is having proper credence and credential, whether that particular what are those arbitration institutions which are having credence? Arbitration institution which has got good quality of arbitrators on their panel are supposed to be good arbitration institution. The arbitration institution which is having good quality of case counsels and staff are supposed to be good arbitration institution. Sometimes people become over conscious with the cost, and they believe that a particular institution may be costlier than other institution, so why should we go for that institution? No, that should never be the consideration. Going to a bad arbitration institution and having a badly administered arbitration may prove to be costlier to you, so don't do that. So that is one of the messages we have to take. So question is, when you are going for all of this, when you are writing your arbitration agreement, you have to think whether the seat of arbitration is a convention country or not, whether whether award passed in that country will be enforced or enforced in other countries, means whether that particular seat, country of that particular seat is signatory to New York Convention or not. So you have to keep all this in mind when you are writing your arbitration agreement. If you want to agree to a particular arbitrator, then agree for that. So you have to create a mental picture, start from the day when dispute will arise and when enforcement will happen. So that mental picture, it needs to be created, and accordingly this arbitration agreement is to be signed. Invariably what happens is arbitration agreements are generally comes last in the priority of the commercial people who sign their main contract. They are more concerned with the commercial aspects. They give least thought to the arbitration agreement. But when they go in dispute with the other side, only thing which a lawyer will look at to start the whole process is how arbitration agreement has been written. And if it is not written properly, you have hundreds of issues. So therefore, arbitration agreements are to be written in most appropriate manner. If you want to have, let us say, institutional arbitration under a particular institution, then best thing to do is all good international arbitration institutions will have their own model arbitration clause. So you have to just look at them and incorporate this in your arbitration, in your main contract, and have this as an arbitration agreement. Don't interfere with, don't tweak that particular model clause, then you may create problem for yourself. I'm getting a lot of questions on seat and venue. We discussed about seat and venue yesterday also, and again I am going to talk about, and let me talk about this because I'm getting irritated with this seat and venue thing. Please appreciate, seat is a legal concept. When you agree for a particular place as your seat of arbitration, seat has direct connection with lex arbitrae. That means arbitration law of that particular seat will apply. Why do you agree with for a particular seat? Because you want to go to that place and have arbitration law of that particular place govern your arbitration process. So that is what is called seat of arbitration. If your award will be passed, you will have to challenge your award only in that particular jurisdiction of the seat. However, even if your seat, let us assume, is Singapore, you can have your hearings in Kuala Lumpur, in Jakarta, in Delhi. In fact, I remember I was doing one arbitration in Singapore way back 2012. And there were occasions when we had hearings in Mumbai. So, but just because we had some hearings in Mumbai, that did not mean that seat of arbitration changed and it became Mumbai. Seat of arbitration never changes. So seat of arbitration will remain Singapore because your arbitration agreement says seat of arbitration will be at Singapore. Now, difficulty arises when in your arbitration agreement you write that venue of arbitration will be Singapore. In those cases, the parties have gone in dispute, and Indian courts, as I said yesterday also, you can refer to various judgments. One judgment of Justice Bhanumati last year, given in Brahmani Pillet matter, which I had argued for successful party, and I got that order in my favor. where Honorable Supreme Court said that though here parties wrote that arbitration will happen at place A, but that did not mean that parties did not intend to have that particular place as seat. If intention was to have arbitration at a particular place, theoretically, technically, parties should have written that seat will be at that place. However, by ignorance, parties had written that venue would be at that place. So court had to interpret that particular arbitration clause, and court said, when I go through this arbitration clause, it clearly indicates that intention of the parties was to go to a particular place A. Therefore, this expressions expression venue should be read to mean seat. I hope I have been able to clarify. Now let us move ahead with the drafting of arbitration agreement. Therefore, arbitration agreement should be in simplest form, which should take care of all the fundamental aspects which you foresee, which you want to have in place. And that is why I said create a mental picture how and in what manner you want this whole process to undergo when you will be in dispute. So write everything necessary for that. Now, sometimes you have a confusion. Parties have a confusion at the time of entering into this arbitration agreement, whether we should go for litigation or whether we should go for arbitration. Now, we discussed yesterday that what are the advantages of arbitration. So if you want to avail those advantages of arbitration, then you will obviously go for arbitration. Now, suppose you have not gone for arbitration, you have chosen, suppose it is an international contract, one side is a foreign party, and you have not written arbitration agreement, what will happen? If dispute will arise, you will have to go to the local court in that particular country to agitate your rights, to pursue your cause of action. In that event, you will be in an alien country. Other side will have a lot of benefits of being a local party. Sometimes in certain jurisdictions, people have this perceived notion that if you go to another country, that particular country's court may be favorable towards the local party. Local party will have lots of advantages. You may have difficulty with the languages. Even in case of Japan, I would tell you, if you have to go to Japanese court, if suppose you have to challenge the award, you have to file everything in Japanese. That in itself is a big issue. So, and second, let us assume that you have got a judgment in a particular country and you want to enforce that judgment in other country, other than that particular country where judgment is passed. Question is, unlike New York Convention, where you have 164 countries which are parties to that particular United Nations Convention, and all 164 countries are bound to enforce the award. In the cases of judgments, you do not have such multi-party, multilateral convention for enforcement of court judgments. You have one convention in for European countries. You don't have any other such convention where you can enforce a judgment rendered in India. You can go to some other country. In India even, suppose you want to bring in some foreign judgment for enforcement in India, under section 13 of Civil Procedure Code, you will have to first see whether India has got reciprocity arrangement with that country or not. So there are various advantages of arbitration, and particularly the enforceability of the decision. That's why you go to arbitration. So all of this are to be considered at the time of writing your dispute resolution and arbitration agreement. Now, another thing which we want to see is, I have come across, and in fact, I have fought certain disputes in court where what had happened was that the way parties had written their arbitration dispute resolution clause, there were two interpretations. Interpretation given by one side, which did not want to go for arbitration, was that it is not an arbitration agreement at all. Now, question is whether a particular agreement is an arbitration agreement or not. Sometimes this in itself becomes a dispute, an issue between the parties. So how do you deal with that? Now, in that particular case, which I was referring to, very high stake dispute, there it was said that in the event of dispute, Mr. So-and-so will decide. That's it. Now, what does it mean? Other sides was saying, which was not interested in going for arbitration, that it is not an arbitration. There are concepts like expert determination. So why it is not expert determination? So therefore, what you have to write in arbitration agreement is that in the event of any dispute arising out of or in relation to this contract, parties will have arbitration under the rules of so-and-so. If you do not want institutional arbitration, then you say Mr. So-and-so will be arbitrator. If you do not want to name the arbitrator, you will say we will have arbitration. So that expression arbitration should be brought in. Then you should write that the award, so this expression again, award should be written there, that award given by the arbitrator shall be final and binding. So these two expressions, final and binding, should also be there. So again, you have to write this. So you should write your arbitration agreement in such a manner that if tomorrow it is challenged, court can say it is arbitration agreement, it is nothing else. So you have to say that intention was to settle. In fact, MK Modi, VK Modi, I think that was the Supreme Court case. MK Modi, if I am not mistaken, was the case where this issue was dealt with, and thereafter there are several judgments which deals with this issue when a particular agreement is arbitration agreement, when it is not. Now, when you talk about institutional arbitration, as I said a while ago, Prajwal Shukla has written, it is KK Modi versus KN Modi. Very right, Prajwal. You are right. I forgot that name. Now, so when you are talking about institutional arbitration, you should be very, very clear that you want institutional arbitration, because institutional arbitration and ad hoc arbitrations have their advantages and disadvantages. Suppose your stake in your the contract is very less. It's not a big stake contract. In that event, and if parties have faith in a particular person, and if parties believe that a particular person can decide this dispute between the parties, so then you can consider having ad hoc arbitration. You can simply say, in the event of dispute, Mr. So-and-so will be the arbitrator. His award will be final and binding on the parties. That particular person, you know, is not going to charge too much of money. You have all faith in him. You have all faith in his ability and expertise, his impartiality. You can go for that arbitration. Then probably you may not want to go for institutional arbitration. But otherwise, if the general consensus globally is that for big size contract, institutional arbitration is increasingly being preferred. Indian government and the courts and the new ecosystem in India is also encouraging institutional arbitration because of its inherent advantages. You have proper administration of your arbitration. Now, one thing which you should keep in mind, you have lots of arbitration institutions mushroomed all across the globe. All arbitration institutions are not good enough to have as a choice. So therefore, you should, before you decide a particular institution, you should go through, inquire about that arbitration institution, see the quality of arbitrators they have on their panel, see the kind of administration, the case administration they do. I know of some arbitration associations where when it comes to case administration, they are not at all good. So I will never go to that particular arbitration institution. If quality of arbitrator is not good, again, I will not go to that particular arbitration institution. Now, I know of certain arbitration institutions, they have got thousands and thousands of arbitrators. They may be worth nothing. So when it comes to good arbitration, when it comes to Sujata Sirolkar is asking which is the best. I would say ICC is best today. No, I'm not saying that other are bad. ICC is very good. SIAC is doing very good. HKIC is very good. LCIA is doing very good. These are some of the good arbitration institutions. I'm talking about international arbitration institutions. So they are quite good. They are doing good job. They are very professional. It should not happen that that particular institution has got thousands of cases, but they don't have people to really administer it properly. Again, one consideration I have seen in many cases people give a lot of thought to is a scrutiny of award. A scrutiny of award is one thing which is a very interesting aspect. One gives a scrutiny of award is a process where award is passed by the arbitrators. That award goes to the court of arbitration of that particular institution, and that particular institution, obviously this award runs through the case councils, passes through the case councils. Those awards are scrutinized. The court of that particular arbitration center will see that all issues raised have been gone into, decided upon. They will ensure that there is no error in that sense where they have omitted to go into certain things, whether interest issue has been dealt with, cost issue has been dealt with. It says my okay, now it's gone. Internet was unstable. Okay, no, but it's better now. It is not interfered with in that particular scrutiny process. But yes, somebody is asking about third-party funding. We'll deal with third-party funding at the end, last day. Now, in the scrutiny, what happens in scrutiny is, if arbitrators know that my award will be scrutinized by the court of arbitration center, where you have very, very senior level arbitration professionals sitting, then obviously they have some sense of accountability in their back of their mind that if I do not pass proper enforceable award, in that case, they will have adverse view against me. Tomorrow, I may not get appointment from that arbitration tribunal. I have to be upright. I have to give enough time to the arbitration award. So these are advantages. Now, ICC has this provision, SIAC has this provision, and some other arbitration institutions also have this provision. So if you want this kind of a scrutiny, then you may go for those arbitration. In fact, in India, we have MCIA, which was set up few years back. That is one arbitration institution one can look at. Now, Government of India is planning to set up an arbitration institution of international level. We are looking forward to it. So question today is, even Justice B.N. Sri Krishna Committee's report has given a lot of emphasis on institutional arbitration. Your arbitration agreement talks about international institutional arbitration. In fact, your 2019 Act also talks about the accreditation of arbitration institutions. That means every arbitration, somebody is asking question whether arbitrant fees and can be written in the arbitration agreement. I'm coming to that. I'll touch upon that as well. So institutional, if you are looking at, it is going to have a lot of bearing on the whole process. If you're talking about institution, give proper thought about the quality and efficiency of that particular institution. Now, again, as I said, we were talking about the seat. When we talk about seat of arbitration, one thing we should also keep in mind of the local arbitration legislation, because this is one thing which is very important. Now, extent of judicial review in that particular jurisdiction. Extent of judicial scrutiny means whether court will, if you will challenge the award, whether court will go into entire facts, entire law, as if that court is a first appellate court, or that court, like in UK court cannot go into facts as per their arbitration act. Their arbitration act, latest act, is also of 96. They will not go into the facts, but in UK you can challenge the award on questions of law. Now in India you cannot challenge the award on question of law. In fact, India used to be taken as not a bad place for arbitration before 2015. In fact, early last year, I was speaking in Kuala Lumpur in a conference of Malaysian International Arbitration Center, MIAC, and there, I had answered a lot of such questions. Questions were, in India, courts are going into all the aspects of the award. So why should we go for arbitration if courts have to ultimately decide the main merit of the case? And they were very right. But I had to tell them that after 2015, whole ecosystem in India had changed. Whole ecosystem in India had changed. Now, not only because of 2015 amendments, but also because of lots of pro-arbitration judgments given by Indian courts. Indian court disagreed with his earlier judgment on certain aspects, came out with Balco judgment, where it talks about how much, whether part 1 of Arbitration and Conciliation Act, which only deals with the domestic arbitration, whether part 1 principles, including section 34 principles, will apply to foreign award or not. As I said yesterday, in your Arbitration and Conciliation Act, you have 2 parts. Part 1 deals with domestic arbitration. Part 2 deals with foreign arbitration. Now, earlier we had certain judgments of Supreme Court which used to say that even with respect to foreign arbitration, part 1 will also apply. However, that view has not been agreed with Balco judgment, 5 judges bench judgment of Honorable Supreme Court, and it was said that earlier law was not a good law. Therefore, now with regard to foreign seated arbitration, part 1 doesn't apply except for the purposes of section 9, section 37 and 27. What does it mean? And you have provisions, similar provisions in many other jurisdictions as well. Suppose I have a dispute, I am an Indian party, I had a contract with Australian party, I wanted to have arbitration in Singapore, my arbitration is going on in Singapore. And suppose Australian company says in that particular arbitration that assets are lying in India, shares are lying in India, money is lying in India because joint venture was running in India, and this Indian company is about to dispose of all the assets, sell all the assets. So what will happen then? Which court you will go to have an order which will restrain the Indian party from disposing of those assets? Otherwise, arbitration itself will become infructuous. So in that case, you have to come to India because only Indian court can at that stage exercise its jurisdiction and restrain that Indian party from disposing of its asset. So for limit purpose, section 9, or obviously if section 9 court disagrees with you, you go in appeal under section 37. Therefore, you have section 37. So 9, 37 and 27 court assistance in taking evidence. Suppose you want to protect a particular asset in India. What do? Come to Indian court, say that protect that asset. Otherwise, my arbitration in India, I am an Australian party. If I cannot obtain any order in Australian court, even if I obtain any order in Australian court, that will not be executable and enforceable in Indian court, because as of now, we do not have any award. Award can be enforced in India, but a court order of a court cannot be enforced in India. So for that limited purpose, part 1 applies. Another very important aspect, invariably, if I have to see parties in this part of world are not generally not going to have their arbitration in USA. Though in USA you have very good institutions, you have courts which are pro arbitration, arbitration friendly courts. You have quality of lawyers are very good, arbitrators are very good, but still you don't know because it is about the distance. So you are your 2 days go just in jet lag. Who wants to do that? So people here to prefer to go to Singapore, people here prefer to go to Kuala Lumpur, sorry, Hong Kong, people prefer to go to London even. Though it is Singapore you reach in 4 hours, 4.5 hours, London you reach in 9 hours. But at least it is manageable distance. Cost. I'll give you an example. There was an arbitration I was doing in Singapore, and for the hearing, the trial for cross-examination and oral submissions, I suggested to have that particular hearing in Kuala Lumpur. Why? Because the facilities are cheaper. Hotels are cheaper. The simultaneous transcription facilities are cheaper. In fact, if you calculate this, it is almost 50% lesser a cost than in Singapore. So I said, let us have the hearing in Singapore. Sorry, Kuala Lumpur. That did not mean that seat of arbitration will change from Singapore to Kuala Lumpur. But these are all the considerations which one has to keep in mind. In fact, I was talking about another thing, that how many tiers of challenges are available in a particular court, in particular country. That is one of the considerations while you are talking about seat. There are certain countries, I just said UK, 3 tiers. India again, 3 tiers. France, Germany, 2 tier. Only 2 courts when it comes to challenge to this. And there are countries like Belgium, Australia, Austria, Switzerland. I discussed this earlier also. You have only 1 tier. Then comes the question, in which country, how much cost you incur in its intel as the court fee. As I said, in Austria, it is 5% of the award value. So sometimes you may say, oh, I'm sorry, that is too costly for me. But then it has its another advantage. Another advantage is, since the party who is challenging the award will have to pay 5% of the award value, just as court fee, which is not refundable, so then challenges are very less. That is another advantage. In fact, for everybody's information, in international arbitration, in 90% cases, award debtors will comply with the award. They do not challenge the award, that is it. In fact, I was talking about that Kuala Lumpur event where I was talking about arbitration and Indian regime. And so one of the questions raised by, in fact, one very popular arbitration personality, I should not name him, he's a good friend, very big international arbitration personality. He says, I agree with Mr. Singh that all of what you are saying about Indian regime to are very good, but what about the percentage of challenges in India? In India, the percentage of challenges to award are very high. That was his question. I said, you were right. But after this amendment, it has gone down substantially for 2 reasons. One reason is that earlier, prior to 2015 amendment, if award was passed and you challenge the award, and here amount of court fee is negligible, the moment you used to challenge the award, there was automatic stay of the execution of the award just because you filed the challenge. So everybody used to go to court. Though courts in Delhi, Mumbai, and some metropolitan cities, courts, and particularly Delhi High Court, has been very pro-arbitration courts. So on the very first day of hearing, Indian courts will use to dismiss maximum number of challenges, saying that no, it has got no merit. But in tier 2, tier 3, and Mufassil courts, in routine manner, courts use, what was the effect? Effect was that there used to be automatic statutory stay of the execution of the award. So award holder had no recourse of execution of the award. But now after 2015 amendment, if you want to challenge the award, first requirement is that you have to first satisfy the court that you have got very good case, that is one. And second thing is, court, it is like a decree of the court, where in first appeal, court will not grant you automatic stay. Court will ask you to deposit some money, either pay to the other side, only then court is going to grant any stay against execution of the award. So numbers have gone down substantially. Yes, we still have some challenges. We still have good number of challenges. It is a cultural issue. It will take a bit of time, but the way things are going, slowly number of challenges will also going to decrease. In fact, the Niti Aayog had issued a circular to all the public sectors and government bodies, which have been the biggest litigants and have most of the arbitrations are relating to public sectors and governmental bodies. There they said that the moment you have award against any governmental body, pay 75% to the award debtors, award holders, against bank guarantee. Why? Because most of those awards used to be in relation to work contracts, construction contract, infrastructure contract. So understanding of the government was that the contractor, if has got an award, he should not wait in perpetuity. They cannot be kept out of money, so they should be paid some money, though against the bank guarantee. And if award is challenged, award is set aside, then obviously you can invoke the bank guarantee if that party is not returning you the money. So that whole culture in India is also changing. One question which was put by somebody was, can we write about the arbitral fees? Yes, in arbitration agreement, you can very well write that arbitrator will be pay X amount of money. But there is a caveat here. Don't write ridiculously low amount of fee which you intend to pay to the arbitrator, because if you throw peanuts, you get monkeys. If tomorrow you will, it's a large scale dispute, high quantity dispute, and tomorrow disputes have arisen, and you insist that the amount which I have agreed in the arbitration agreement should only be paid to the arbitrator, you will not get good arbitrator. I know of some of the arbitrations where no good arbitrator was ready to arbitrate because arbitration amount was so low. And what happens? That arbitration amount, the fees which you have agreed in your arbitration agreement, itself becomes a weapon in the hands of the party who doesn't want dispute to be resolved. He would say, I will not pay more than that. Then you say, I am ready to pay the differential. Then comes the question, how can arbitrator accept X plus Y from one and only X from another? So that again raises serious issues. So therefore, if you want to write, and in any case, why should you write arbitration cost now until unless it is a very low value contract? But in high value contract and mid value contract, you can agree for Schedule 4 of the Arbitration and Conciliation Act. That is a which is not very high, but not very low either. You will get arbitrators. However, top tier arbitrators in India are not invariably not ready to do arbitration if you have agreed for Schedule 4 arbitration fees. They will say no, it doesn't compensate us properly. So therefore, I would say at this stage you have to take a bold decision. Don't become penny wise and pound foolish. Though you have a very complex contract, you have a complex construction contract which will have huge stakes involved, and you insist that I will pay very less money. So that it is like being penny wise pound foolish, because ultimately the dispute resolution depends on the quality of the arbitrators. You have arbitrators and you have arbitrators. You have arbitrator who can arbitrate for few thousand rupees, but you will not get good arbitrators, arbitrators of reputation, arbitrators of expertise. So that is what is very important. That again, you can also write who will bear the cost, but better is to not go on the cost and this particular arbitration fees issue in the arbitration, because now you have got a very robust cost regime in India. Now, under section 31A of Arbitration and Conciliation Act, it has adopted all the best practices on cost, which was otherwise the global best practice. May I say a bit about this? See what happens in big arbitrations. What do you mean by big arbitration? Complex arbitration, where stakes are substantially reasonably high. Cost is an issue. Cost plays a major role. Amount of money which you have to pay to either institution or to the arbitrators or to the lawyers, because in those matters you engage lawyers of, again, reputation. Now what happens is that this is a big issue, and particularly in international arbitration, costs are very substantial, because parties, the lawyers, the arbitrators, all have to fly to the seat of the arbitration. They have to stay in hotels. So obviously good arbitrators, good lawyers will not fly in less than business class. They will not stay in less than 5-star hotel. So all of that, and then their fees, all of this becomes a substantive amount. Now, how it is dealt with? One very important, so your Arbitration and Conciliation Act follows the principle and doctrine of cost follows the event. That means party who loses in the arbitration will pay the cost to the winning party. There is a doctrinal here difference. There is a theoretical difference. This cost follows the event principle is essentially the principle which originated in UK, and it is being followed in this part of world. But when it comes to USA, culturally, traditionally, whether it is court proceeding or arbitration proceeding in US, there they follow different theory. They do not follow cost follows the event theory. The theory which they follow is that parties should bear their own cost. It has got its own theoretical philosophical regions. That is not something I'm going to discuss today, because as of now we are not discussing cost issue. I may touch upon a bit when I go to the cost, which will be after pronouncement of award topic which I'll be dealing with. Somebody had just written a question, Sumit Kansal. He says, what happens if some claims are accepted, some are dismissed? It happens. Invariably, it happens that all the claims are not awarded, or all the heads of claims are not awarded. You may ask for 10. What may be awarded to you is only 5. Then here the cost follows the event principle has to be seen slightly with nuance. And that means tribunal will see how many claims you raised. Suppose you raised claims under 10 heads, and you have been awarded claim only under 1 head. Then you have lost your claim for under 9 heads. So here you will suffer the cost then. So apportionment and all issue will have to be looked into. Another important aspect, I'll deal with it in detail when I go to cost. Another aspect which arbitrators will look at is the conduct of the parties. Whether during the course of arbitration proceeding, parties conducted themselves well or not, whether they were involving themselves in delaying tactics or not, whether their behavior was proper or not, whether they wanted to frustrate the whole proceeding or not. These are all the relevant considerations which arbitration tribunal will look into while passing the award on cost. So these are should be better left to be decided by the tribunal, and generally no party will agree that even if I win the arbitration tomorrow, if there is any dispute, I'll pay you cost. So even if you want, most of the time you will not find other contracting party. Please appreciate, in order to execute an arbitration agreement, just because you want something does not mean that other party is also going to, oh, somebody says that is it correct that arbitration in arbitration cost is divided equally? No, this is not a thumb rule, this is not a rule, and this should not be the rule. It depends on how many claims have been awarded, how many claims have been refused, what has been conduct of the parties. All of this needs to be seen, not otherwise. Now we have gone into this arbitration agreement in fairly exhaustive manner. I'll touch upon slightly different issue, that is about arbitration agreement itself, and that is multi-tier dispute resolution clauses. Trend nowadays, particularly in construction contracts or sometimes even in commercial contracts, is that parties write multi-tier dispute resolution clause. What does this mean? Multi-tier dispute resolution clause means that there will be more than one dispute resolution provision available to the parties when dispute will arise. So what are those dispute resolution provisions available? So what we see invariably in dispute resolution clauses, they say, as and when dispute will arise, parties will first negotiate in good faith with the other party. If negotiation fails, then parties will go for mediation or conciliation, or they can go for arbitration. In construction contract, you may have a provision that if dispute arises, parties will go for negotiation. Thereafter, they will go for dispute resolution board or dispute avoidance board, or they can go to engineer. First, engineer will decide. Only after the engineer has decided and you are unhappy with this, you can go to arbitration. So what does it mean? It means these are pre-arbitration dispute resolution mechanism agreed between the parties. Now, one may ask this question, should we write this or should we not write this? See, all of this pre-arbitration dispute avoidance or dispute resolution mechanism are first of all non-binding, unlike arbitration, which is a binding form of dispute resolution. Those are all not binding, but it is basically, it is said to be cooling off period. Parties goes in dispute, both sides are very agitated. So these dispute resolution clauses give them opportunity to cool down, give them opportunity to revisit their own position, have third party independent parties view on the dispute. So they take more pragmatic approach during those processes, or when they come for arbitration, they are more pragmatic in their approach and views. Now, question is, should we write and should we not write? My only caution here is that if you have written all of this, then you follow this. While writing this, you should be very clear in mind that I am going to follow this with diligence, with all seriousness. Note that just because you have written it, you don't intend to go by this, then it becomes disaster. Sometimes one of the parties who doesn't want to have arbitration, they will, in arbitration, they will challenge the jurisdiction of the tribunal itself, saying that pre-dispute resolution mechanisms have not been gone into. And if those pre-dispute resolution mechanisms were worded in mandatory manner, worded in such a way that tribunal can hold that these were preconditions for arbitration, in that case, arbitration itself will fail. Tribunal will say, I have no jurisdiction because you have not made the precondition for dispute resolution for this arbitration. So, like I'll give you an example. Lots of construction contracts have provisions for dispute resolution board, extending or ad hoc dispute resolution boards. Means the board which we created, some people will be nominated by both sides. If it is a standing dispute resolution board, that the moment contract starts going on, contract, suppose construction has started, you have to constitute that board, and that board will, as and when any issue arises between the parties, that board decides those disputes, so that parties are going ahead with the contract. You may have ad hoc dispute resolution board mechanism, which is meant to have been in place after dispute has arisen. But what happens? None of the parties will ever have dispute resolution board in place, or they will never go to dispute resolution board, and they will straight away go to arbitration. So that is why I said, when you are writing your arbitration agreement, have a mental picture of the whole process. Write only what you mean. Do not write arbitration agreement just for the sake of writing and tomorrow create problem for yourself. So never do that. And as I said, now I have covered this arbitration agreement. I wanted to cover this today's entire session on arbitration agreement, because what I thought was that this is a very important aspect and we must devote sufficient time to this particular aspect of arbitration agreement, which I thought of doing, which I have done. Now, question is, there will be other aspects which we need to go into, and another aspect after this would be, what if you have an arbitration agreement, and despite of existence of arbitration agreement, one of the parties to that arbitration agreement, instead of going to court, instead of going to the arbitration, goes to court. What happens then? For that, you have a specific provision in your Arbitration and Conciliation Act for domestic arbitration as well as for foreign arbitration. If it is a domestic arbitration, suppose you had an arbitration agreement, one of the parties has instead filed a suit without going into the arbitration, then in that event, you have to go to that court where that suit has been filed and file an application under Section 8 of Arbitration and Conciliation Act with a request to that particular court that please refer the parties to the arbitration. Since we have got arbitration agreement, and since we have arbitration agreement, it means that parties relinquished their right. Now recall that in the beginning of this today's session, I said purpose of arbitration agreement. One of the purposes is that you relinquish your right to go to court. So once you have relinquished your right to go to court, irrevocably, you cannot go to court. Now, suppose suit has been filed, you go to court, you file an application under Section 8 of Arbitration and Conciliation Act. Or sometimes what parties do is, parties file their written statement But in the written statement, they take a preliminary objection, that party should be referred to arbitration. However, section 8 categorically says that you should file your application under section 8 of Arbitration and Conciliation Act before filing your matter on substance. Before filing your substance, submission on substance means before you file your written statement, you should have gone to the court, else you waive your right to seek reference to arbitration. So one should be very, very careful with this, that if I want arbitration, other side has gone to court, what I will do is, I will go to court, straight away file an application under section 8 of Arbitration and Conciliation Act and get the matter referred to arbitration. Now, if it is with respect to international arbitration, again, in India, you have in part 2, section 45 of Arbitration and Conciliation Act. See, remember yesterday I was saying New York Convention became popular and very popular. And one of the reasons of this popularity is that it enforces not only the award, it also enforces the arbitration agreement. So you have an arbitration agreement for international arbitration, and one of the parties goes to a court in one jurisdiction. Other party can go to that jurisdiction, file an application under section 45 of the Arbitration and Conciliation Act, and Indian courts will say, sorry, you cannot pursue your remedy in court, you have to go to arbitration. So that is very important aspect, and that we had to deal with this. Apart from this, another aspect, we have 5-6 minutes, or if the organizers want some question answers for today, I can take them. Else I'll move on to the different issue, different subject. Can Rahul hear me?
Yes, sir.
Do you want to have questions now, or do you want me to go ahead with other aspects?
So
I have taken a lot of questions.
Yeah, you have. Since you have taken a lot of questions, you can go ahead with the discussion.
Okay. Okay. Now, after this section 8 and section 45 aspects, now I'll go to yet another aspects. Sujata says very beautifully explained. Thank you, Sujata. Now I'll touch upon yet another aspect today, that is interim measure.
Sorry, sir, to interrupt you. Your video is not you are not visible, sir.
I am not visible.
Yes, sir.
Am I now?
No, sir.
Oh, the host has asked you to start your video. Start my video. Oh my God. उसको बुलाओ. या तुम कर सकती हो? I have lost.
एग्जिट कर दी क्या आपने?
रिमूव कर दिया उसने.
उसने आपको रिमूव कर दिया, तो होस्ट है, उसके बिना तो आप आ नहीं सकते हो लिंक.
Sir, you are still in the meeting.
Okay.
You have to just start your video. On the bottom of your screen, there's an option to start the video.
No, I don't see anything like this.
No, it's a support chat.
I think we have now only 4 minutes left. So
right.
we can conclude today's proceeding, and we will assemble tomorrow. In any case, I'm going to start a new topic. So I'm not going to cover it. It will not get covered in 4 minutes. So we will take it tomorrow. I'll start with this tomorrow. So tomorrow proceeding can be brought to an end. And with my all thanks to you, Rahul, your team, and all my thanks to all the participants. Thank you very much for all your patience. Thank you very much.
Thank you, sir.
Thank you so much, Ratan sir. Thank you so much for your time. Thank you, participants. In the Zoom meeting and on the Facebook Live, we will be getting together tomorrow at the same time on the same platform. Thank you so much for joining.